Who came in late. My name's Amy Quinn. I'm from the Community Health Law Project. We're a nonprofit legal service agency who represents people in a variety of matters, but one is the housing, eviction, landlord-tenant matters. My coworker here is Madeline Coughlin. We just are doing a brief overview of tenants and who tenants are, and we're about to get into the Anti-Eviction Act. Everybody please help yourself to refreshments in the back. There's sandwiches and soda provided by the City of Asbury Park.
Yes, and anyone who came in late, up in the front here, there's an attendance sheet. Please put your name. You don't have to give any personal information. Just your name and what town you live in, please. So if you haven't signed the sheet, please do so. Thank you.
Okay. The main law in New Jersey governing evictions from residential premises is the Anti-Eviction Act, as it's commonly known. There are a few tenancies that aren't covered by it, but probably the vast majority of people are covered by it. The main class of excluded people are people who live in owner-occupied premises. Anybody live in owner-occupied premise here? Okay, so we don't even really have to worry about that. Pretty much everybody else is covered by the Anti-Eviction Act. That would include rooming houses and boarding homes and any kind of multiple family dwelling. So the most important thing about the Anti-Eviction Act, and the reason that they enacted it not that long ago, but about maybe 20 or 30 years ago, was that there's a terrible housing shortage in New Jersey, as you probably all know. So the government wanted to protect the housing that people had. So they said, listen, you can stay in New Jersey. You're effectively a tenant for life unless your landlord has a good cause reason for evicting you. And then they listed all of the good causes, and there are actually, I think, 17 of them listed in the statute. So you can only be evicted for one of those 17 reasons in New Jersey. And when you hear what they are, they make a lot of common sense. It's all about being a good tenant. And if you are a good tenant, in most instances, you can pretty much stay there forever. There are a few things where people's circumstances, the owner wants to move in, things like that. But for the most part, it's all about being a good tenant. Almost all the grounds, and in fact, I think I could say all but one, require some form of advance notice. Before the landlord can take you to court to evict you, he has to give you at least one written notice. Most cases involve 2 written notices. The first one is called a notice to cease, which is like a warning notice, where the landlord says, this is the thing that you're doing that I don't like, please stop. If you don't, I'm going to have to take further action. Then if some time goes by and you're still doing whatever the landlord is complaining about, they'll send you what's called a notice to quit. That says, you've continued to do what I don't want you to do, now I'm terminating your tenancy. The notices to quit, and there's like a different time period for every one of these causes of action, but sometimes it's 3 days, for example, if you damage or destroy the landlord's property, and it can run to condominium conversions, can be 2 years or more. So all the notices are different. They can be varying time periods. The landlord can't file an eviction complaint against you until the time period in the notice to quit has expired.
Maybe we can give an example. So an example would be, let's say your landlord's complaining about your TV. Your TV is very, very loud at very odd hours, like 2 or 3 in the morning. Your landlord, it's blaring. Your landlord's going to send you a notice to quit saying, listen, and he needs to be pretty specific about it. He needs to be specific about it so you can correct it. So it can't be stop doing, put the noise down. Well, he probably could do put the noise down, but he should be pretty specific so you know what he's addressing.
Yeah, and refer to the lease.
Right.
Like this, paragraph 3 of your lease says that you cannot have loud noise after midnight, weekdays, as it's disturbing other tenants. It's like he should be, if the term is in your lease, he should be very specific in the notice what lease term you're violating.
Right. So he sends you a letter saying, listen, you got to turn your TV down as per your lease.
The dates it happened, and very specific.
Okay. A time period passes. You did, whether you did it or not is open for discussion. But let's just hypothetically say he doesn't think you did. He sends you a notice to quit. You didn't stop doing what I asked you to do, and I'm now going to proceed to try to evict you on this ground, only on this ground. So, if he wants to get you out for non-payment of rent, but he brought you to court for this TV issue, he can't get you out for non-payment of rent.
Okay. So as Kim was saying and Amy was saying, the notices have to be specific. So the reason for that is in landlord-tenant court, you go, and your trial is the day that you go to court. So you go to court with your notices and your summons and complaint, that's all you have. So you won't know what the landlord is going to say unless they give you pretty much a lot of information in the notices. So the law says they have to give you as much as they can. Now, if you live in public housing, or if you have a Section 8 voucher, there are even more additional notice requirements. In addition to the ones that are in the statute, the Anti-Eviction Act, then public housing cases have even more notices. For example, a non-public housing tenant would not get a notice in the case of a non-payment of rent situation, but in public housing, you get a notice, a 14-day notice, before you can be evicted for non-payment of rent. And the other thing about the public housing notices is they have to offer you, in almost all cases, an opportunity for what's called a grievance hearing. Anybody here in public housing? No? Okay, so we'll buzz right by this. But if you were, it is great to take advantage of those grievance hearings because many of the cases can be resolved if you just go in, meet with the landlord, and talk through what's going on. How about Section 8? Anybody Section 8? Okay. The Section 8 cases don't usually require any additional notices, but the landlord does have to serve a copy of the eviction complaint on the Section 8 housing authority. So if they don't do that, the judge will dismiss their case. So that's one thing to think about if you're in that situation. So if we don't have anybody in public housing, then we really don't have to be too worried about this. How about in any kind of publicly funded housing, like Phillips Seaview Towers or any of those ones? No? Senior citizen housing? If they're publicly funded, they do have additional notice requirements. So, okay.
If anyone has questions as we're speaking, you can stop us and ask them at the time.
Yeah, how come you cannot counter sue